Thanks. This is a momentous day. I guess more accurately put, yesterday afternoon was a momentous afternoon. The people's right to an initiative and a referendum on legislative actions was upheld by the Idaho Supreme Court in what I regard as a very important decision. It was unanimous. It was a powerful decision. It was a very clear decision. The right of the initiative and referendum is a right that is reserved to the people by the Constitution of the state of Idaho. The plain language of the Constitution, strictly construed, should have resulted in the court finding that attempts to unduly restrict the initiative through Senate Bill 1110 were unconstitutional, and that's exactly what the court did. Democrats tried to warn the Republican majority that passed this bill that this would be the outcome. Nonetheless, of course, we sat on pins and needles through this litigation, hoping that the outcome would be as we believed it should be, as we believe that the law has always been. That the whole purpose of the initiative and referendum is really to be a check on legislative power. And that's completely appropriate. All branches of government have checks on their powers. This is a sovereign right of the people, and the court has upheld that right. And having read the decision, it really wasn't a close call. And we just wish that the legislature, this legislative majority, would stop the 100-year plus effort that has existed since the initiative and referendums rights were added to the Constitution, would just stop this 100-year campaign to try and undermine this right of the people. I actually think that the Idaho Supreme Court decision might become a model for similar decision-making in other states in the United States that have the initiative and referendum. And I'm very pleased with the result. Thank you.
And then we'll switch it over to Senator Ward Engelking. Thank you, Senator Burgoyne.
Thank you, everyone, for being here. It is exciting to be here today and see this great news. But I have to tell you that Senate Bill 1110 was one of the most egregious bills I have seen since I've been in the legislature. It stripped the citizens of Idaho of their constitutional right to use the initiative or the referendum process to legislate directly. And that's so important, as Senator Burgoyne said, to be a check and balance for the legislature. And that bill set the bar so high that really the only issues that had a chance of making it to the ballot were those issues that were backed by industries with deep pockets that could hire an army of people to gather signatures. And that's not what the Constitution intended. It intended for the citizens to be able to get initiatives on the ballot and referendums. And you know, the majority party was told by present and past attorney generals that there were constitutional issues with this bill, and yet they ignored those opinions and passed it anyway. And the minority party, we debated passionately against this because we felt so strongly that stripping the people of their constitutional right is never okay. And it was the current process we have is not used that often. It's not being used all the time, and it's already difficult. So this bill was not needed. And more importantly, it's unfortunate because not only was this bill not needed, but the fact that we had to battle it in court, once again, an unconstitutional bill, the people of Idaho, the taxpayers, are going to pick up the tab for all the court costs. And we have literally in the past spent over $5 million, almost $5 million in court challenges. And these are bills that have, that we knew had constitutional issues, but we continue to push them forward. And I say that we, meaning the majority party, continues to push them forward. We've yet to win one of those constitutional challenges. So we've spent over $5 million or close to it of taxpayer money. And I think it's time that we take a look at these bills and we listen to people who are knowledgeable about the legality of these bills, and that we quit pushing bills forward that we know are going to be deemed unconstitutional.
Thank you both so much. And now we're going to open it up to reporters for questions. Feel free to unmute yourself, or if you're more comfortable asking them in the chat, that's totally fine. And I can just read them off. And if you want to utilize the raise your hand function too, so we can do this in an orderly fashion, whatever's easiest, but feel free to start asking questions.
Joe Paris here with KTVB. I don't know if it's too early to ask this question, but is there a ballpark estimate on how much this will cost taxpayers?
I saw a report, Joe, that Mr. Myers had already charged $180,000. I don't know the accuracy of that. I did see it in the media. And if that's a benchmark against what the value of the other attorney's fees in the case are, there are several attorneys involved. We're looking at a significant amount of money.
And I might add that the legislature okayed not only the Attorney General, who is usually the person that would represent the state in these issues, they okayed a private company, a private attorney office to, and that I think is being billed at about $470 per hour. So not only do we have the Attorney General's fee, and that I think is close to $80 an hour. We get a really good deal on that, and we have very qualified people in the Attorney General's office to represent us, and that's their job. But yeah, and we're going to be looking at the other side. So it is very costly, and we knew ahead of time that this was going to be challenged in court, and that there were constitutional challenges and problems with it.
Other questions?
Senators, are you aware of any efforts to bring a similar bill back again in the next session? Do you know of any efforts that there might be a similar effort to limit the initiative process, maybe not as much as 35 districts, but something that's more restrictive?
Well, we've seen 3 different initiative bills pass, well, 2 passed since I've been in the legislature, and then so I'm sure we're going to see more of an effort to restrict the citizens' constitutional ability to put an initiative on the ballot. But it seems ridiculous when currently the process we have in place is very difficult and it's not used excessively. So these bills aren't needed.
No reasonable legislator, in my estimation, would go down the road of trying to defy this Supreme Court ruling and place undue restrictions on the initiative process. The Supreme Court's decision went to the trouble of laying out the 100+ year history of the legislature trying to undermine the initiative and referendum right. And it's not a pretty history. It's a history of legislators arrogating to themselves the power to try to nullify the Idaho Constitution, and that should not be repeated. If there's one thing that we all hear from constituents, and if there's one thing I think Idaho stands for, it's the idea that the people are sovereign, not the people they elect, not the people who are supposed to represent them, and it's the idea that people have rights, and this right should not be meddled with. And I think that trying to pass legislation to continue this 100-year history and try to take this right away from people is going to be met very swiftly and very strongly from the Supreme Court of Idaho, and that's as it should be. So I certainly wouldn't advise anybody to go down that road. I think they're wasting their time. I think they're wasting the taxpayers' money. And I think they're injecting doubt into what should be an appropriate process to play out in elections when initiatives qualify for the ballot.
And I might add that we all take an oath when we come to the State House to uphold the Constitution of Idaho. And it's a very solemn oath, and I take it very seriously. And I'm hoping that our colleagues will take a look at that and say, hey, this is serious. We need to make sure that we're upholding the Constitution of Idaho.
I'm going to turn it over to Betsy and then Nicole for questions.
Excuse me, the Supreme Court in its decision took great pains to say, while we are putting the law back to what it was back in January with 18 districts rather than 35, we are not saying 18 districts is constitutional. And we are dismissing that without prejudice because it wasn't directly challenged in this case, but it still could be challenged. Do the two of you believe that the current law that we're back to now, requiring 6% of registered voter signatures from 18 of 35 legislative districts, is constitutional? And do you foresee any legislation addressing that current law?
I think its constitutionality is highly questionable. And I think that if the legislature decides to try and pass something more restrictive than that again, we'll have another lawsuit, another opportunity for the Supreme Court to address the issue. And I think the second time around, the people who are supportive of the people's right to an initiative and a referenda will not fail to challenge the law that's now existing today, that the Supreme Court has said is now in effect. That won't happen again. The next time that one of these lands in the Supreme Court, the 18 district statute is going to be front and center along with the new law in the Supreme Court. And so I think the legislature, the majority in the legislature need to think long and hard about whether they're going to jump out of the frying pan that they probably feel like they're in today and get into the fire, because I think they may just end up losing it all.
And in reality, the current law was reaction to Medicaid expansion getting put on the ballot. And that's that has not been in effect that long. And so, it is something they may choose to challenge, and we may be looking at that down the road.
I'll turn it to Nicole.
Hi, this is Nicole Camardo with Idaho News 6. Yesterday, we all received the statement from Scott Bedke, who says that, the House Republican caucus is disappointed with this decision, that it's limiting the voice of rural voters. What would both of you say to that? Do you believe that this does limit the voice of rural voters, or do you think that it could help them when it comes to these ballot initiatives?
Well, the Republicans, the Republican leadership and the Republican majority keep trying to divide Idahoans against each other. This political tactic has swept through America like a wildfire, a very hot, very destructive wildfire. We are Americans, we are Idahoans. If our politics are going to be successful, we have to learn to live together and to work together. And this attempted division of saying that there are rural interests and there are urban interests and that they need to be divided and one needs to be vindicated over the other. No, we have human beings in the state of Idaho. We have Idahoans, and all Idahoans' rights in the political process need to be respected, need to be honored. And I'm just afraid that I'm disappointed in Speaker Bedke's comments, because they just continue to feed the division that is so destructive.
And I would agree with that. We are, I grew up in rural Idaho, and I currently live in Boise. My roots are rural, and a lot of us have real empathy and concern about everything that happens in rural Idaho, because it is so important to the entire state that we represent their needs and their wishes too. It's not, we don't just represent our district. We try to pass laws that are good for all Idahoans. And this bill simply silenced the voice of all Idahoans and did nothing to promote rural engagement. And in fact, it probably did more to discourage rural Idahoans from getting involved, because they knew that one single district could veto, in essence, all the work of the rest of the state. So I don't buy that argument at all, and I do think it's divisive.
I wondered if either, oh, I'm sorry, I just wanted a quick follow-up. I wonder if either of you would like to address what the Supreme Court actually said on that question about whether the law was helping promote rural voices or in fact hurting them.
Well, the Supreme Court said that it doesn't really help rural voices. And I certainly agree with that. I think whenever any voter, any person eligible to vote in Idaho is denied their right to have their impact on the political process, it harms every single one of us. And we need a process where the people of Idaho can be engaged, can participate in their political process in an unfettered fashion. We need to quit setting up elected officials as thinking that they know best about everything. Good elected officials listen to the people that they represent. And this was simply an attempt to insulate elected officials from having to listen to people. That can't be good. It can't be good for anybody, whether they live in rural Idaho or urban Idaho. The people that I represent, many, many, many people who live in the city of Boise are first-generation urbanites. Many of them grew up on farms and ranches. Ada County is, in respect, a rural and agricultural county, notwithstanding the large city that lies within it. Other large counties in Idaho also have many rural residents who live outside of those cities, and many agricultural interests. Again, this is an insult and an attack on the character of Idaho. And thank goodness our Supreme Court had the wisdom to stand up and say, stop it.
I think the fact that it was a unanimous decision says it all. They knew this was not good for Idaho. This did not uphold our Constitution.
Are there any more questions out there? Looks like Scott's going to ask something.
So there were a few Republican legislators who voted against the bill. What kind of conversations did you have with legislators on the other side of the aisle, and what was your sense of their resistance to the bill? And do you sense that there'd be similar alliances with folks on the other side of the aisle if this does come up again?
We work closely with our colleagues on the other side of the aisle, and there are Republicans there who work with us on many issues, and they felt the same as we did, that this was too restrictive, that it did not allow for the citizens of Idaho to get an initiative on the ballot. They had the same ideas and opinions we did, and I think that they are going to be upheld in their view of that. They get pushed hard by leadership to to vote with the majority, but they were very courageous, and they knew this would impact the citizens' ability to do their constitutional duty as put an initiative on the ballot if they so choose.
The Republican legislators who voted against Senate Bill 1110 did not surprise me. These are people who have an independent streak, who think for themselves, and who, in my estimation, and I know these legislators, in my estimation, these people are the kind of legislators who honor the idea that they work for the people don't work for them. So their votes were not a surprise. The surprises to me were other people who I thought would oppose Senate Bill 1110 who did not. Some of the debate that we heard in support of Senate Bill 1110 was really shocking. To hear a legislator stand up and debate publicly that in the Medicaid expansion initiative People didn't know what they were voting for. Well, there's two answers to that. One, I think it's pretty clear, and I think people in Idaho understand that people did know what they were voting for. But, you know, if the people didn't know what they were voting for, it was the responsibility of their legislators to inform them. Leadership requires that public servants go out and inform people of the information they need to make intelligent decisions. And if legislators are not doing that, shame on them.
Well, and the reality is those same people are the people that them in office voted for them. So if we're questioning the voters' ability to know what they're doing, then we have to question, I guess, all of their votes. But my feeling is that citizens of Idaho are pretty knowledgeable, and especially when it comes to issues that are on the ballot, that seems to get their attention.
One last quick one, if I may. Given the views of the majority and the comments from the speaker, what is to stop the Republican majority from continuing to push this fight, though it is, in fact, as we've seen, a costly and losing fight?
The courts will stop them. That's what the courts do in America. The courts are a third branch of government that has the ability to push back on the excesses of other branches of government. The legislature in this area, I hate to keep repeating it, but I think it bears repeating. This history goes back over 100 years of trying to destroy this right. And the court has pushed back and pushed back hard. And I have no doubt that the court will continue to stand up for the rights of the people and to stand up constitutional government and to put the legislature back in its place.
And I'm hoping the people will stand up and say enough. We don't want this type of bill passed again. I'm hoping they will stand up, because I think there were, at least in my area, people were incensed about this and the fact that the legislature was trying to strip them of power and take it for themselves. So I'm hoping the people will stand up too.
You know, public servants, public elected officials in the United States and in Idaho don't enjoy a great deal of respect. It's this kind of behavior by a legislature that earns the disrespect of people. And I have to agree with Senator Ward Engelking. My constituents are completely fed up with this kind of behavior. You know, they don't get all that upset. They may have their disagreements on quite a few of the issues that we deal with, but the anger, the depth of disrespect voiced out of this legislature for the people of Idaho and their supposed ignorance in not knowing what they voted for, that kind of attitude really does not go over well with the people in Idaho.
We'll see if there's any final questions from folks. And if not, we'll go ahead and wrap up. Thank you so much for joining us. I really appreciate it. And thank you, senators, for taking the time to do this as well.
Thank you, everyone.
Thank you.
Have a great afternoon.
Appreciate it.
Thank you.
Thank you.